Welcome back. I've been going through this week's submissions, and this one stopped me halfway through the first page. Not because of anything loud, but because of a single line buried in the third act. She signs the paper. She actually signs it! And if you know what that paper is, you know exactly why that line is the most dangerous thing in the story. You're watching historical manhwa. The alarm sounded at 5:47 a.m., and I was already awake. I'd been lying in the dark for an hour, listening to the rain against the window, a slow, irregular sound, like someone tapping to be let in. The ceiling above me was the same eggshell white I'd stared at the night before my signing the first time. I'd forgotten that detail. Strange what comes back. I sat up. The clock on the nightstand read 5:48. In 7 hours and 12 minutes, I would be sitting in a glass-walled conference room on the 31st floor of Herondale Capital's headquarters, holding a pen above a 43-page arbitration agreement. I already knew what was in every clause. I'd read the document in my previous life, first in the room, panicked, as 60 seconds before the HR assistant told us we had to initial each page, and again later, in the offices of 3 different lawyers who'd each delivered the same verdict. Once signed, your claims are individual, not collective. You can't pool them. The company will outlast you in solo arbitration. I reached for my phone. The date confirmed what I already knew, October 14th. I lay back against the pillow for exactly 30 seconds. I gave myself that. 30 seconds of feeling the weight of it. The full architecture of what I'd built over the past 6 months, the 12 names on the complaint, Gideon's paralegal who'd worked until 2 a.m. to finalize the exhibits, the filing timestamp that would read 9:03 a.m. in the federal court's electronic docket. Then I got up. The kitchen was cold. I hadn't turned the heat on yet. It was mid-October, and I kept telling myself I'd wait until November, which was either frugality or superstition at this point. I filled the kettle and set it on the burner. In my first life, I had loved this kitchen. The morning light came in at an angle across the counter and turned the steam from the kettle gold. Dorian used to say it was the only genuinely beautiful thing about my apartment, which at the time I'd taken as a compliment about my taste. I understood it differently now. Dorian Ashford, Managing Director, Herondale Capital. 11 years older, twice as polished, and so careful about what he let you see that it took me 3 years to understand I'd only ever seen the lobby. He'd recruited me out of a competing firm when I was 28. The pitch was professional. I had a reputation for quantitative analysis that a larger platform could leverage. The pitch was also personal in the way that only becomes clear in retrospect. He was very good at making professional interest feel like personal recognition. By the time I understood what was happening between us, I was 31 and principal analyst, which meant I was the 3rd most senior woman on the floor and the only one still underpaid by roughly $40,000 annually compared to my male equivalents. I didn't know the number then. I found it out 6 months before the arbitration agreement when Josephine, one of the junior analysts, came to me with a screenshot she'd taken by accident. A salary distribution spreadsheet that someone in finance had left open on a shared drive. Her name in one column. A male colleague's name in the adjacent column. Same title, same year of hire, $22,000 apart. She'd come to me because I was the most senior woman who hadn't yet left or been managed out. I'd told her to send me the screenshot, not to discuss it with anyone else, and to keep her head down. Then I spent 6 months quietly not knowing what to do. I went to Dorian. He told me the discrepancy reflected performance-based variation and squeezed my shoulder in the way he did when he thought a conversation was over. I'd let it go. That was the first death. The second came 8 months later, when the arbitration agreement appeared. Herondale had been sued before. Individual claims quietly settled. But something had changed in the previous year. 3 women at a competitor had managed to pool their pay discrimination cases by arguing their individual claims arose from a single policy, not separate decisions. The resulting settlement had cost the competitor $40 million. The legal department at Herondale moved fast. Within 6 weeks, every employee below managing director received a mutual dispute resolution update. You had 48 hours to sign, or your employment would be considered voluntarily terminated. The agreement's key provision: any dispute between employee and employer must be resolved through binding individual arbitration. Class and collective actions expressly waived. No pooling, no discovery that forced disclosure of company-wide pay data. No jury. I signed on October 14th at 11:04 a.m., along with everyone else in the firm, including Josephine. We lost, all of us, individually, over the following 18 months, in separate arbitration proceedings that cost each of us money we didn't have, and produced settlements so small they were insulting. My own was $6,200. The arbitrator, selected through a process that, I later learned, strongly favored repeat player employers, found that my wage discrepancy reflected, quote, documented performance differentials. I never found out what the documented performance differentials were. Arbitration discovery is limited by design. Dorian moved on professionally and personally. By the time I was midway through arbitration, he'd made partner and married Lavinia, a woman who had joined Herondale's HR department the year before, who I had sat across from in mediation sessions, whose neutral expression I had not then understood. I quit after the arbitration. I got a job at a smaller firm. I worked. I tried to let it calcify. I was 41 when I died in the rain on the interstate, coming home from a deposition that had lasted 11 hours and produced nothing. I was 31 when I woke up again, 6 months, 4 days, and approximately 14 hours before the signing. The first thing I remembered, coming back, was the smell. I'd been somewhere else. Not a place with language or geography, just a quality of stillness. And then I was in my bed in April, with the windows open, and the air smelled like the flowering tree on the corner that I hadn't thought about in 9 years. I lay there for a very long time. But the mind does something strange in those first hours. It catalogs. Every item of information I had from the future arranged itself with a sort of clinical patience. Josephine's screenshot, the arbitration agreement's filing date, the pay gap data I'd only been able to reconstruct partially in my first life, because by then I'd lost access to the company's systems. The names of the other women at Herondale who'd filed and lost. And then the things I'd learned too late. Employment law, which I'd taught myself in the 18 months between the signing and my death, because grief does something specific to people who were good at school. It turns into research. I knew now, things I hadn't known then. I knew that the National Labor Relations Act, Section 7, protects concerted activity among employees, including, as a string of court decisions had established, the right to collectively pursue legal claims. I knew that an arbitration agreement that waives those rights entirely is under the right legal argument, potentially unenforceable as a violation of the NLRA. I knew that the Federal Arbitration Act creates exceptions. I knew that the EEOC can investigate and litigate independently of any arbitration clause because it is a federal agency, not a party to the employment contract. Most importantly, I knew that under Federal Rules of Civil Procedure Rule 23 and relevant Seventh Circuit precedent that a lawyer named Gideon Prosper had explained to me 2 years before my death in a consultation I'd had with him about a different case, too late to use. A class action complaint, once filed and docketed, what cannot be retroactively subjected to an arbitration clause signed after the filing date. The agreement only controls future claims. A claim in federal court, time-stamped before the pen touches paper, belongs to the court. I had 4 months and 11 days before the mandatory signing. I got up, made coffee, sat at the kitchen table in April sunlight, and started writing down names. The first thing I needed was a lawyer, not a general employment attorney. Those had given me the same answer in 3 different offices in my first life. Sign, fight it in arbitration, and hope. I needed someone who worked class and collective actions specifically, who understood the NLRA argument, and who wouldn't dismiss what I was about to tell them. The problem was credibility. I was 31 years old. I had a salary I couldn't disclose without violating a confidentiality clause I'd signed during onboarding. I had Josephine's screenshot, but Josephine didn't know I had it yet. She wouldn't come to me with it for another 2 months in the original timeline. And I had no standing, technically, to walk into a law firm and say I needed to file a class action against my employer before a specific date in October. I spent the first 3 weeks doing nothing that could be traced. I accessed public court filings instead. PACER, the federal court record system, gave me every case Herondale had ever been named in. There were 11. 3 of the most recent were employment claims that had been compelled to arbitration after the plaintiff signed an agreement. The court orders cited the same arbitration clause, the same language. And I printed all of them from a public library computer, paid in cash, and kept them in a folder in my apartment that I labeled, with no irony intended, Tax Documents 2019. In the meantime, I went to work. I was precise and neutral, and I left exactly on time, which in my first life I had never done, because Dorian had once told me that people who left on time were people without ambition. And I had internalized that so deeply, I'd spent 8 years staying late to prove something to a man who had already decided what I was worth. I stopped answering his personal texts within the hour. He noticed by the end of the first week. "You seem distant," he said, leaning in the doorway of my office on a Tuesday afternoon. His voice was pleasant. It was always pleasant. That was the thing about Dorian. He never raised it. Not the pleasantness was the weapon. "Quarterly review preparation," I said without looking up. "I'm behind." He paused for a moment. Then, "Let me know if you need anything." I said I would. He left. I waited until I heard his door close down the corridor. Then I opened the company intranet's job posting archive, which was searchable by compensation band, a feature most people didn't know about and which HR had apparently never thought to restrict, and pulled every posting from the past 4 years. Same titles, same bands, different salaries posted. I screenshotted each one on my personal phone, emailed them to a new address I'd created solely for this purpose, and deleted the sent items. It took 11 evenings. I had names and ranges for 42 positions. I found Gideon Prosper through the court filings. Then his name appeared in a case from 2 years prior, a collective action against a financial services firm in the Northern District. The case had settled for $11 million. The settlement agreement was redacted, but the court's approval order described the class as consisting of 89 employees and noted that counsel had demonstrated, quote, exceptional command of the intersection of NLRA protections and arbitration clause enforceability. I read that order 4 times. I called his firm's main line and asked for an initial consultation, which cost $300 and lasted 45 minutes. His office was in a building that smelled like old carpet and printer toner. He was 60-something, with reading glasses pushed up on his forehead, and a manner that suggested he had been deeply skeptical of everyone he'd ever met, and found it professionally useful. I told him I worked at a financial services firm. I told him I believed there was systematic gender-based pay discrimination affecting at least 20 employees. I told him I had documentary evidence from the intranet that I'd gathered personally, and that I had reason to believe a mandatory arbitration agreement was incoming within 4 months. He looked at me for a long moment. Why 4 months? This was the part I'd thought about carefully. I couldn't tell him I'd been through it once. I said, because the firm is currently in litigation with a former employee on a wage discrimination claim. Once that's resolved, and it will resolve in the firm's favor, through arbitration, I believe the legal department will move to close the gap. I want to file before that happens. He looked at me for another long moment. You'll need co-plaintiffs, he said. To certify a class, we need named plaintiffs who've suffered the same or substantially similar harm from the same policy or practice. One person with screenshots from a job board isn't a class. I know, I said. I'm working on that. He folded his hands on the desk. The NLRA argument is viable, but it's not settled law. If we file and the agreement still goes through, the company will immediately move to compel arbitration. Our counter-argument is that the claims were filed before the agreement was signed, so it can't retroactively bind these plaintiffs. That argument holds, but it will be litigated. You will be in district court for at least a year before this goes anywhere productive. I'm prepared for that, I said. Are your co-plaintiffs? I said, they will be. He studied my face. Then he said, come back when you have 3 named plaintiffs and their documentation. I won't take a retainer until then. I need to know you're serious. I stood up. I put on my coat. At the door, I turned back and said, I'll have 5. I had 7 by the end of July. The thing about asking someone to file a federal lawsuit against their employer is that you have to do it without saying those words. I knew how to approach Josephine because I'd known her, in my first life, for 2 years, before she'd finally stopped pretending everything was fine. She was 24, originally from outside the city, and she'd grown up in a household where you didn't make noise about things you couldn't fix. She was good at her job and had learned to calibrate her expectations accordingly. I asked her to lunch in the second week of May, which was earlier than it had happened in the original timeline. In my first life, we'd become close slowly, gravitating toward each other by proximity. I needed to accelerate that without being strange about it. We went to a sandwich place near the office that was loud enough that no one would overhear us at a back table. I asked her directly whether she was happy with her compensation. She stiffened slightly. Why? Because I'm not, I said, and I'm looking at data that suggests neither are a lot of other people here. I'm not asking you to do anything. Yet I'm asking whether you've noticed anything. She studied me the way young women in professional environments learn to study senior women, evaluating whether this is a test, an alliance, or a trap. After a moment, she said, "My offer letter had a salary range. I was given the bottom of it. Do you know where your male peers were placed in that range?" She looked away, then back. One of them mentioned his number during onboarding. He'd assumed we'd gotten the same. I didn't say anything. I let the silence do the work. She said quietly, "I didn't do anything about it." "You had no leverage," I said. "That's not the same as doing nothing." I told her I was in the early stages of consulting with someone about options. I told her that if she wanted to be part of that conversation, I'd include her. And if she didn't, this lunch had been about the food. I told her that nothing she told me would be shared with anyone in the firm. She looked at her sandwich for a moment. Then she said, "Tell me what you need from me." By the end of June, she had written out a detailed account of her hiring, her compensation history, her performance reviews, and 3 specific instances in which male peers had received promotions she'd been passed over for. She'd written it in a password-protected document and emailed it to the address I'd given her. She never mentioned it at work. She never changed her behavior with me at work, which was the more important thing. She kept her head completely still while I built the frame around her. The documentation was the engine. Everything else was superstructure. By late July, I had Josephine's records, the intranet job posting screenshots, comparative salary data for 42 positions over 4 years, performance review excerpts from 6 employees who'd given me written permission to include their anonymized data, email correspondence, which I'd been quietly forwarding to my personal account, using the firm's policy of allowing personal device access to company email, that showed management had discussed the pay structure in explicitly gendered terms on at least 3 occasions. The email was the strongest piece. There was one from Dorian to the head of compensation from 2 years ago that read, in part, "The women on the analytical team have different retention patterns than the men. They leave for life reasons more often, which means the long-term investment in their compensation packages is lower return. I'd suggest we reflect that in the band positioning." He'd written it on a Tuesday afternoon. I know this because I'd been in the office that Tuesday afternoon, and I could place precisely what I'd been doing while he typed it. I'd been preparing his quarterly presentation. I forwarded that email to my personal account on a Wednesday evening in August. I sat with it for a while after. Not with anger. Anger had made me slow in my first life, had blurred the edges of things I needed to see clearly. What I felt instead was something closer to confirmation. Every assumption I'd operated under for 3 years presented at last as documentation. I saved it in a folder labeled Tax Documents 2019, subfolder B. Gideon reviewed everything I brought him in 3 separate meetings. He was methodical. And he pushed back on the weaker pieces. The performance review data was circumstantial. The anonymized format made it difficult to draw direct causal lines. But the email, he said, was different. "This is the kind of evidence that survives a motion to dismiss," he said. "It shows policy intent, not just outcome." "I have 2 more like it," I said, "from different executives." He looked at me over his reading glasses. "How are you getting these?" "The firm allows personal device access to company email," I said. "I'm accessing my own email account on my own device." "That's a contested area," he said. "Some courts have found that even forwarding your own work emails can violate computer fraud statutes if the information is proprietary. We need to be careful about what we use and how." "Tell me the line," I said. He told me the line. So I stayed on the right side of it. By September, I had 9 named co-plaintiffs. Gideon had reviewed all 9 files. He'd sent the complaint to his research attorney 3 times for revision, each time tightening the theory of harm, sharpening the damages calculations. We had a Title VII claim, sex discrimination and compensation, affecting 11 named plaintiffs. We had an Equal Pay Act claim for the same 11, plus 2 additional employees whose male equivalents we could document by name. And we had an NLRA argument as a standing defense against the anticipated motion to compel arbitration. The EEOC charges, required as a prerequisite for the Title VII claims, had been filed under seal by mid-September on behalf of 11 employees to allow the agency's mandatory investigation period to run. The EEOC filing was independent of any arbitration clause. The agency is not a party to the employment contract. The agency can investigate regardless of what any employee signs. The class action complaint itself was ready by October 1st. Gideon and I went through it line by line. "Filing date," he said. "We have a window. If the arbitration agreement goes out on October 14th, as you're projecting..." "It goes out October 14th, I said. "Then we file the morning of, before anyone in that building has a pen in their hand." 9 in the morning, I said. "The signing is at 11. He wrote it down. His paralegal, a woman named Hadley, who worked with the focus of someone on a personal mission, confirmed she'd have the exhibits ready for electronic filing no later than 8:45 a.m. As the filing timestamp would be the most important document in the case. Here's the thing about watching someone who has hurt you from a distance you designed. You become a student of their assumptions. Dorian assumed many things during those months, and the most important was this: that my withdrawal from him personally had been temporary. A moody spell. Something about the quarter, or stress, or some inexplicable weather pattern that would eventually clear. He was accustomed to women adjusting to him. I did nothing to correct the assumption. I was professionally precise, personally cool, and I laughed at his jokes in meetings at a frequency calibrated to maintain our relationship at exactly the temperature of cordial but unremarkable. In late July, he took me to dinner. Well, we went to a restaurant in the West Loop where the lighting was warm and the noise level just high enough to make conversation feel intimate. He ordered wine he knew I liked. He had an excellent memory for small preferences, which in my first life I'd taken as evidence of care. He said, "I've been thinking about your future at the firm." I said, "Oh? You're one of the most technically skilled analysts we have. There are discussions happening about a senior director track. I think you'd be a strong candidate." I looked at him across the table. His face in candlelight, which I had once found beautiful in the specific way of things that are composed rather than genuine. "What would that involve?" I said. "Partnership discussions would start next year. Compensation structure changes significantly at that level." He meant, "I'll take care of you." That was the subtext. I'll take care of you, and in exchange you stay in the arrangement we've been in, and you stop being distant, and you remember what I can give you. I said, "I appreciate you thinking of me. I'll keep that in mind as I work through the quarter." He smiled. Not his full smile, the one that reached his eyes only when he was genuinely pleased with how something was going. This was the other one, the one that meant he was recalibrating. "You seem different lately," he said. "Is everything all right?" "Quarterly review preparation." I said, "I'm behind." I watched his face process the repetition. He recognized it. He had a good memory, as I said, but he didn't know what to do with it. We finished dinner without incident. And he paid. He held the door. On the sidewalk, he said something about coffee sometime that week, and I said that sounded nice. And we both understood the conversation had ended without resolving anything. I took a cab home. I sat in the cab and calculated how many days were left until October 14th, and I felt nothing specific. Just the hum of the engine and the city lights going past the window, and a kind of steadiness that in my previous life I hadn't found until far too late. I'd assumed, coming back, that Lavinia would be harder to read. In my first life, I'd only understood what she was after the fact, pieced together from company announcements and the particular blankness of her expression during mediation sessions. She'd joined Herondale's HR department as deputy director 9 months after I'd started my relationship with Dorian, and I had not at the time connected the two facts. I connected them now. Lavinia Seraphine, the name she'd been hired under, was 36, with a background in management consulting and employment compliance. She was careful and correct in every interaction. She processed things visually. I noticed, watching her in meetings, that she never took notes by hand. She photographed documents with her phone. Everything was deliberate. Everything was for a file. She'd been Dorian's before me, or simultaneously. The timeline, which I'd spent considerable effort reconstructing, was genuinely unclear. What was clear, she was going to become the primary point of contact for the arbitration agreement rollout. She was already, by September, running what the company was calling an Employment Relations Modernization Initiative, which was the name HR had given to the process of quietly preparing 43 pages of binding legal documents. I watched her in September the same way I watched everything, from a distance, with the specific patience of someone who has already seen the ending and is now studying the mechanism. One afternoon, passing her in the corridor, I stopped to ask about a benefits update that had apparently gone out to the wrong distribution list. She sorted it out immediately, efficiently. Before she turned back to her desk, she said, "Are you finding the benefits package overall competitive with other firms you've considered?" It was a strange question, precise, in a way that most HR small talk isn't. "I'm not currently considering other firms," I said. She held my gaze for a moment. And then, "Good to hear." I went back to my office and sat with that exchange for 10 minutes. She knew something. Not about the lawsuit. That was impossible. But she knew something about me and Dorian was off equilibrium, and she was watching to see which direction I'd move. I had no interest in her knowing anything more than that. The kettle clicked off at 6:14 a.m. I poured the water. The coffee was dark, and the steam came off it straight in the cool kitchen air. I stood by the counter and drank the first half of it before sitting down. My laptop was open on the table. I refreshed the email. At 6:20, Hadley's message came through. "Exhibits finalized. Uploading to CM/ECF now. Should have a docket number by 8:30 at the latest. Will confirm immediately." I replied, "Confirmed." I went to shower. But the water pressure in my apartment was inconsistent. There was a low moan in the pipes every time I turned the tap, which I'd spent 8 years meaning to report to the building manager. I stood under the warm water and went through the order of events one more time. Gideon would arrive at the federal courthouse at 8 a.m. His paralegal would have the complaint and all exhibits ready for electronic filing on the CM/ECF system. The complaint named 12 plaintiffs, 9 of the original group plus 3 additional employees who had agreed in the final 2 weeks. One of whom had been approached not by me, but by Josephine, who had by October become very good at having quiet conversations. The complaint alleged systematic gender-based pay discrimination in violation of Title VII of the Civil Rights Act and the Equal Pay Act, in a pattern of retaliatory performance assessments against employees who raised compensation concerns, and a structural policy of compensation banned management that, per Dorian's email and 2 supporting documents, explicitly considered sex as a variable in long-term investment calculations. The damages sought were back pay, compensatory damages, and injunctive relief, meaning the court could order the company to change its pay practices going forward, not just pay out to the current plaintiffs. At 11 a.m., I would walk into a conference room on the 31st floor and sign a 43-page arbitration agreement, with one difference from the first time. I took the train instead of a cab. I'd taken a cab the first time, anxious, worried about being late, all wanting the privacy of a window I could look out while I tried to decide whether I was making a mistake by not finding a way to object. I'd spent the ride composing and discarding arguments I couldn't make without revealing that I'd compared notes with other employees. This time I took the train. I stood the whole way, even though there were seats, because I wanted to feel the movement. The lobby of Herondale Capital's building was polished stone and floor-to-ceiling windows that looked out onto a street already busy with the mid-morning loop. I checked my phone at the elevator bank. 8:47 a.m. Hadley's message had come in at 8:31. Filed, docket number assigned, timestamp 8:29 a.m. Confirmation attached. I looked at the timestamp for a long moment. 8:29 a.m. The complaint was in the federal docket. It had a case number. I owed 12 named plaintiffs with their signed declarations, their documentation, their individual accounts of the specific dates and amounts they had been underpaid. The complaint was now a matter of public record. The claims in it belonged to a federal judge. No arbitration agreement signed after 8:29 a.m. could touch them. I got in the elevator. They'd put us in a meeting room on the 29th floor, 2 floors below the main HR suite, which was carpeted and had windows that faced the parking structure. There were 12 of us at different times, filing in between 9 and 10:30. Coffee had been provided, which in my first life I'd taken as a professional courtesy and now recognized as management of the pre-signing window. Keep people comfortable. Make the space feel normal. Josephine arrived at 9:15. She found me by the window and stood beside me without saying anything for a moment. Then, very quietly, "Gideon confirmed?" "Filed at 8:29, I said. She exhaled once through her nose. It was barely audible. "The others?" I said. "Everyone got the message this morning. Same thing I got?" I'd sent a single line to each of the 12 plaintiffs through the encrypted messaging app we'd been using at 6 a.m. Filed. Today proceeds as planned. Behave normally. She nodded. Nobody looked at their phones in here. "Good," I said. We separated. I went to refill my coffee, not because I needed it, but because moving through a room with intention is less conspicuous than standing still in a corner. Lavinia arrived at 9:45. She was dressed precisely. Dark suit, hair pinned back, the kind of put together that functions as a signal about who controls the environment. She carried a tablet and spoke quietly with the HR assistant near the door. Then she moved through the room in a slow, purposeful way that I recognized as a monitoring pass. She stopped at me. "Vesper," she said, "how are you finding the process so far?" "Fine," I said. "Straightforward." "I want you to know the agreement is very standard," she said. "Our counsel has ensured it aligns with current best practices." I looked at her. Her expression was professionally neutral. The mask she wore for things that mattered. Under it, something was attentive, something that had been watching me since September. "I'm sure it is," I said. She moved on. At 10:15, I was asked by an assistant I'd never seen before if I'd step down the hall for a moment, and Dorian would like a word before the formal session. I followed the assistant to a smaller room, a side conference space with a round table and no windows. Dorian was already there. He'd poured himself water, but hadn't touched it. He looked, for the first time in months, slightly less composed than usual. "Vesper?" he said. "Dorian?" He waited for the assistant to leave and close the door. Then, "I want to be honest with you about something." That sentence. In my first life, I had heard it twice from him. Once when he told me his marriage had ended, which was a lie designed to simplify the situation. Once when he told me the arbitration outcome wasn't something he'd had input into, which was a different kind of lie. Both times I had believed it, because I had wanted to, because I had thought that honesty from him, when it came, was currency. I said nothing. I let the air in the room sit. "The agreement today is firm policy," he said. "It's going to every employee below MD. I want you to know that I think your future here is strong, and that if there are concerns about anything, the right channel is always through me or through the formal HR process." He paused. "Not through outside channels." I studied his face. He had heard something. Not about the filing. That was impossible. It had only been in the docket for 90 minutes, and the complaint was under a temporary seal that wouldn't lift until the court processed the filing fully. But something had reached him. A nervousness. Maybe one of the 12 had been less careful than I'd thought. Maybe it was just Dorian's instinct, which was genuinely good, picking up on a frequency he couldn't yet name. "Yeah, I appreciate you telling me that," I said. "Vesper." His voice shifted slightly, lower, more personal, the register he used when he wanted me to remember what we were to each other. "I need to know we're aligned." I held his gaze. In my first life, at this point in a conversation, I had generally felt something. The specific anxious pull of needing him to think well of me. The want to be in his good opinion, to stay there, to be worth keeping. I felt none of that. What I felt instead was simpler and much older. The kind of clarity that comes when you've already made the decision and you're just watching the last scene play out. "We're aligned," I said. "I'll see you in there." I left the room first. The conference room on the 31st floor was glass-walled on 2 sides and looked out over the city. But 11, AM sunlight came in at a flat autumn angle and lay across the table in a pale stripe. There were 12 chairs. Most were filled when I arrived. Lavinia stood at the head of the table, near a cart where the agreements had been stacked. Spiral-bound, tabbed, each employee's name printed on the cover page. The HR assistant handed me mine as I sat down. I set it on the table in front of me without opening it. I knew what was in it. 43 pages. The key provision was on page 7. Any dispute arising from or relating to your employment must be submitted to binding individual arbitration. Class and collective actions are expressly and irrevocably waived. Irrevocably, they'd underlined it. I had not forgotten that detail. Lavinia gave a presentation. It lasted 12 minutes and covered the history of the company's dispute resolution framework, the benefits of arbitration, speed, privacy, cost-effectiveness. For the company, she did not add, and the process for initiating a claim. She was thorough and precise, and did not once use the word waiver. Then she said, "We'll now take a few minutes for you to review the document before signing. Please initial each page and sign on the final page." The room went quiet in the specific way that rooms go quiet when 43 pages of legal text are being held by people who are afraid to ask questions. I opened the agreement to page 7. I read the provision one more time, then I closed the document. I picked up the pen. I initialed page 1. I was on page 19 when my phone buzzed. I had silenced it before entering the room, but I'd left the vibration on because I needed to feel it. I reached into my jacket pocket without looking at it and kept initialing. Page 20, page 21. Josephine, 2 seats down, made a small sound, barely a clearing of the throat, and then was perfectly still. Page 22. At the head of the table, Lavinia's tablet lit up. She glanced at it once, then back at the room, then down at the tablet again. Her hand moved to the device. Her expression was professionally calibrated, but her stillness changed quality. Page 25. The door to the conference room opened. One of the managing directors, Emmerich, whose name I knew because he appeared as a respondent in the complaint, leaned his head in and gestured at Lavinia. His face was arranged correctly, but his jaw was doing something it didn't usually do. "To page 28. Lavinia excused herself from the table in a voice that said this was routine. She left the room with Emmerich and the door clicked shut behind them. I turned to page 29. The HR assistant at the sidewall shifted her weight from one foot to the other. Her phone was in her hand. She looked at it, put it down, picked it up again. Page 31. I could feel the room's temperature changing. Not literally. The HVAC continued its low hum. The pale sunlight lay across the same stripe of table. But something moved through the 12 people in that room, a current of information that arrived the way all-important information eventually does. Not through channels, but through faces. Page 35. Josephine's hand, visible at the edge of my peripheral vision, initialed her page without hesitation. Page 38. Oh, and then the door opened again. Lavinia came back in, and her expression had changed in the specific way that expressions change when someone has just been told something they did not expect and has decided to process it standing up. She looked at the table. 12 people with arbitration agreements and pens. 9 of them were on page 38 or beyond. She said, "I need to ask everyone to pause for a moment." The room went quiet. I set my pen down on page 39. Lavinia said, "There's an administrative matter that's come to my attention. I'm going to need a few minutes to address it before we continue." She looked at me. I looked back. The HR assistant had moved toward the door. Lavinia held up one hand, a small gesture, and the assistant stopped. Dorian came in. He'd moved fast. His jacket was on, but not fully settled. Always one cuff slightly turned. He never came to mandatory staff sessions. That was the nature of the meeting's design. MDs don't sign because MDs were exempted from the agreement by a carve-out on page 41. He stood at the far end of the table and looked at the 12 people in the room. Then he looked at me. "There's a filing," he said, "in federal court, this morning." He was telling me, not the room. I said, "I'm aware." The room processed that. Lavinia said, controlled, "Vesper, you'll need to come with me." "I will," I said, "as soon as I finish." I picked up the pen. Page 39, page 40. The agreement was nearly complete. I could feel Dorian watching me, and I did not look at him. Page 41, page 42, final page. I signed my name in the signature line, Vesper Ardmore. The letters were clear and even. I'd written this name enough times that it came out the same way now. The same weight, the same angle of the V. I set the pen down. Josephine set hers down 2 seconds later. By the time the last person in the room had signed, 9 of the 12 plaintiffs had completed the agreement. They took me to a different room. Smaller, no windows this time. An interior space that smelled like recycled air and the particular quality of carpet that has absorbed years of difficult conversations. Dorian came in last. Lavinia stood near the door. He said, "Explain what you've done." I looked at him. He was standing very still, which was what he did when he was genuinely angry, as opposed to the performative precision he used when he wanted to seem reasonable. I filed a class action complaint in federal district court this morning, I said, on behalf of 12 current employees of Herondale Capital, alleging systematic gender-based pay discrimination in violation of Title VII and the Equal Pay Act. The complaint was docketed at 8:29 a.m. Dorian said, "You just signed an arbitration agreement." "Yes," I said, "that agreement cannot retroactively bind claims already in federal court," I said. "The complaint was filed before any of us signed. The claims belong to the court. Your arbitration clause controls prospective disputes, not ones already on the docket." Silence. Lavinia said carefully, "That legal theory is contested." "It is," I said. "Your counsel is welcome to move to compel arbitration. Gideon Prosper will oppose. And I expect the motion to be fully briefed within 60 days. Dorian looked at me for a long time. I have thought about what I expected from his face in that moment. In my first life, I had imagined many versions of a confrontation with him. The kind that only exists in the imagination, which is always cleaner than the real version. I had imagined anger or guilt or the particular cruelty of someone who has decided to stop pretending. What I got was something different. What I got was the expression of a person whose map of the world has been revised without his permission. He'd understood me as a certain thing. An employee who loved her work, a woman in a relationship with him that he had defined and would continue to define. The woman who'd stayed late to prove something, who'd adjusted to him over and over, in the thousand small ways that adjustment happens when the power in a room runs one direction. He had not understood me as someone who'd been building something for 6 months without him knowing. "You forwarded company emails," he said finally. "My own emails," I said, "which I accessed through my personal device via the firm's Bring Your Own Device policy. Your legal team drafted that policy. There's a confidentiality clause in your employment contract, which covers client information and trade secrets," I said. "Not internal HR communications or compensation data. That distinction will also be briefed." He said, "This will cost you your position here." I said, "Yes." He looked startled. He'd expected either denial or the beginning of a negotiation. He was good at negotiations. "You understand that?" he said. "I've understood it for 6 months," I said. He looked at me then in a way he hadn't since before the relationship had settled into its arrangement. Something open in it. Something that might have been genuine bewilderment. And underneath the bewilderment, something that was beginning to look like retrospect. I didn't wait for it to arrive. "I'll have my formal resignation on your desk by the end of the day," I said. "Gideon will be in touch with your legal team." I picked up my coat from the chair where I'd put it. "Vesper?" Dorian said. I stopped. "The email," he said. "The one about retention patterns. About the women on the team." "Yes," I said. "I wrote that—" He paused. "I wrote it as a practical observation, not a policy directive." I looked at him for a moment. "You wrote it," I said. That's what it will be." I left. The corridor outside the conference room was empty. The floor's usual low hum of productivity, keyboards, phone calls, the sound of the elevator bank, continued below as though nothing had happened. That was the specific quality of institutions. They absorb events without stopping. Josephine was waiting near the elevator bank. She had her coat and her bag. Her expression was the careful neutral she'd been wearing for 6 months, maintained, functional, giving nothing away to anyone passing in the hall. She looked at me when I came around the corner. I said, "Gideon will call you this afternoon." She nodded. "The others know the same," I said. "Don't discuss it here. Not today, not ever, from this building." "I know," she said. The elevator arrived. We got in. Going down, she said, "Did he try to—" "He tried several things," I said. "None of them worked?" She was quiet for a moment. Then, "What happens now?" "Now Herondale's legal team files a motion to compel arbitration. Gideon opposes. The district court hears the argument, probably in the new year. In the meantime, the EEOC investigation runs separately. The EEOC can subpoena company-wide pay data in a way that neither of us could in individual arbitration." "And us? Our jobs?" I said. "We've both tendered our resignations, effectively, by filing. They'll formalize it today or tomorrow, but we knew that." She nodded. She'd known that. We'd gone through it in September, specifically and carefully. Each of the 12 had to understand that filing was the end of their employment at Herondale. That there was no scenario in which you filed a federal discrimination complaint against your employer and kept your desk. The question was whether what came after was worth it. For 11 of them, the expected monetary recovery, back pay alone, before compensatory damages, before any upward adjustment for Dorian's email, was between $40,000 and $90,000 per person. For Josephine, whose case was cleanest, it was closer to $120,000. "You've been here longer than I have," Josephine said as the elevator reached the lobby floor. "What do you do now?" I thought about my apartment in April, the tax documents folder, the $300 consultation, the months of careful nothing. I thought about Hadley printing exhibits at 2 a.m. and Gideon's face when I'd said, "I'll have 5. "I already have a job," I said. She looked at me. "Gideon offered me a position at his firm 3 weeks ago," I said. "Paralegal while I finish the bar exam. I passed the February sitting. Results come in December." She stared at me. "I studied for it starting in April," I said. 12 hours a week. I was always going to need to leave Herondale at the end of this. The elevator doors opened onto the lobby. "You've been studying for the bar," she said. Not quite a question. "In April it seemed like the most useful thing I could do with whatever came next," I said. She laughed. Just once, short and surprised. The kind of laugh that comes out when something is both funny and not funny at all. When you've understood for the first time the full scale of what someone has been doing quietly while standing next to you. We walked through the lobby, the polished stone floor. The floor-to-ceiling windows. The street outside still busy. Going past without regard, I held the door for Josephine, and then I walked out. The motion to compel arbitration was filed 11 days later. Gideon opposed it with a 40-page brief. The central argument was straightforward. The arbitration agreement was signed after the complaint was filed. Under established Seventh Circuit precedent, an arbitration clause cannot retroactively compel arbitration of claims already before the court. Additionally, as a secondary argument, the NLRA preempted the class action waiver provision to the extent it prevented concerted legal activity by employees on a matter of mutual concern regarding working conditions, and compensation under relevant NLRB guidance was a working condition. The court scheduled a hearing for January. In the meantime, the EEOC investigation moved forward. The agency sent Herondale a formal demand letter for comprehensive pay data going back 5 years. All employees below managing director, by gender, title, and compensation band. Herondale's response was that the data contained proprietary information. The EEOC's response to that response was a subpoena. I watched all of this from Gideon's office on the 14th floor of a building that smelled like old carpet and printer toner, which I had come to find genuinely comfortable. My desk was near the window. Hadley sat across from me. We did not discuss the strangeness of working on a case I was also a party to. Gideon had been careful to separate my work on other matters from anything touching the Herondale file. But sometimes, late in the afternoon, when the light was going gold and the printer was running and I was looking at something unrelated and ordinary, I would think about October 14th, 8:29 a.m., the timestamp on a federal docket, the least dramatic-looking document I had ever been part of. The results came on a Thursday morning in December by email at 7:14 a.m. I was in the kitchen when my phone buzzed. The same kitchen, the same eggshell ceiling, the kettle going on the burner, the morning light coming in at an angle across the counter. I opened the email. I read it. I set my phone face down on the counter and stood there for a moment with the steam from the kettle rising around me. I called Gideon at 7:16. He was already in the office. He was always in the office before 8. He said, "Congratulations, counselor." His voice was dry and precise, which was the most warmth he generally deployed. I said, "Thank you. I'll need a few weeks to get my bar number and get formally added to the Herondale case." He said, "Whenever you're ready." I hung up. I stood in my kitchen for another minute, with the kettle steam and the morning light and the ordinary apartment where I had, over the past 9 months, built something from the specific materials of what I already knew. Not new, not a different life, the same life, with better information and more time. The hearing was in the morning, in a federal courtroom that smelled like old wood and central heating. I was in the gallery, not at the counsel table. I was not yet formally on the case, and I wanted to observe cleanly. Gideon argued for the plaintiffs. Herondale's outside counsel was a firm I recognized from my first life. To no useful effect, then. I knew their arguments before they made them. The judge, a woman in her late 50s with reading glasses and a manner that communicated she had heard every possible legal argument and was interested only in the ones that were correct, asked Herondale's counsel one question at the end of their presentation. "Your agreement was signed at 11 a.m. on October 14th. Counsel for plaintiffs has presented a federal docket timestamp of 8:29 a.m. on October 14th. Explain your theory of why this agreement governs those claims." Herondale's counsel said, "The agreement covers all disputes arising from employment, regardless of when those disputes were." The judge said, "That's not what I asked." The hearing lasted 40 minutes. The judge issued a written ruling 6 weeks later. She denied the motion to compel arbitration. The class action would proceed. The ruling was 42 pages. The key passage, which I read in Gideon's office at 6 p.m. on a Tuesday in February, in the kind of silence that isn't silence, but is the absence of any sound I needed to make, held that an arbitration agreement executed after a complaint is filed cannot divest the court of jurisdiction over claims already properly before it. The word properly had been argued over for 4 months. It was the right word. I didn't see Dorian again until the mandatory mediation session in March. He was across the table, with Herondale's legal team on either side of him. He looked fine, well-dressed as always. The years of constructed composure were still in place. He had made partner by then. The announcement had gone out in November. Lavinia was not there. She'd left the firm in January, which I'd learned from a court filing that listed the company's HR contacts. Her LinkedIn showed a move to an independent consulting practice. I did not think about what that meant for her. It wasn't mine to think about. Dorian looked at me across the mediation table and said nothing. Our lawyer spoke. The company's opening offer was low enough to be an insult, which was a mediator's term. Gideon said it was a standard first position. We would not be settling at a first position. During the break, I stood by the window in the hall. The city below was gray with March, the trees in the plaza out front still bare. Dorian came and stood near me. He didn't say anything at first. He looked at the same view. After a moment, he said, "Is this what you wanted?" I thought about the question, not about what to say to him, and about the question itself, whether what I wanted was a meaningful frame for what had happened and was happening. I said, "No." He waited. "What I wanted was to be paid what I was worth," I said. "I did that for 9 years, and it produced $6,200 and a letter that said my performance differentials were documented." I turned to look at him. This is what I had to do instead. He said nothing. I went back into the mediation room. The preliminary settlement was reached in April. Gideon had told me, in February, that the EEOC subpoena had produced numbers that changed the case. The company-wide pay data, once disclosed, showed a gap that was larger than we'd estimated. 41 women below managing director. Gaps ranging from $18,000 to $62,000 annually, and over a 5-year period for the longest tenured employees. Total back pay before the EPA's automatic liquidated damages provision that doubled the back pay figure, approximately $3.2 million. with liquidated damages, $6.4 million, plus compensatory damages for the Title VII claims, which covered professional harm and documented career interference, negotiated at an additional $2.1 million, allocated across 12 named plaintiffs and an opt-in class that had grown to 31 employees once the filing became public. Total, $8.5 million. The 12 named plaintiffs received a higher allocation due to their role in the case, per the settlement formula. Josephine's individual share was close to what Gideon had estimated in September. Mine was slightly higher because I had the longest tenure and the largest documented gap. Saw it on the morning the settlement was finalized. I was in Gideon's conference room with the 12 named plaintiffs and their counsel, which was now, formally, both Gideon and me, each of us working in our respective capacities. The settlement agreement required the company to implement a pay equity audit within 90 days, conducted by an independent third-party firm and reported to the EEOC. It required annual disclosure of gender pay gap data for 3 years, and it required the removal of the collective action waiver from the company's employee arbitration agreement going forward, pursuant to the NLRB's guidance on NLRA Section 7 rights. Irrevocably, I thought. They'd underlined it, on page 7. On a Tuesday in April, 1 year and 6 days after I'd woken up with the windows open and the smell of the flowering tree on the corner, and I walked out of the settlement conference at 4:30 p.m. The street was cool and flat and busy. I stood on the sidewalk for a moment. The city went on around me the way cities do, without interest, without adjustment, without noticing that something had finished. My phone buzzed, a text from Josephine. "It's done." I typed back, "It's done." She replied, "Are you okay?" I looked at the question for a moment. I was not euphoric. I had not been since October 14th, since 8:29 a.m., since the moment the filing confirmation had come in, and I'd understood that the frame had locked and the mechanism had worked, and the thing I'd built was doing what I'd built it to do. That morning in December, when the bar results had come in, I'd stood in my kitchen and felt something that wasn't quite happiness and wasn't quite relief, something that had no clean name. It's the sensation of having used the time correctly. I typed back, "Yes." I put my phone in my pocket. I walked to the train station and took the train home. The tree on the corner of my block had come back. April does that eventually, regardless of what you're doing. Small white flowers that had been there last April when I woke up and decided what to do with the months I'd been given. I didn't stop to look at them. I went inside.